Perfect. So thank you so much, Justice Kirby, for coming along to our discrimination law class to talk about law reform. I thought I might just briefly introduce you, although I think to everyone in this room, you probably need no introduction. But the Honourable Michael Kirby, AC, CMG, is an international jurist, educator, and former judge. Served as Deputy President of the Australian Conciliation and Arbitration Commission from 1975 to 1983. Very importantly for us, he was Chairman of the Australian Law Reform Commission from 1975 to 1984. Judge of the Federal Court of Australia, President of the New South Wales Court of Appeal, President of the Court of Appeal of the Solomon Islands, which is becoming a bit more relevant, and Justice of the High Court of Australia from 1996 to 2009. Justice Kirby has been heavily involved in law reform and advocacy on law reform for a very long time, and we're very lucky to have him here today. So, Justice Kirby, is it okay to pass on to you to talk about your experiences and perspectives on law reform, and then we'll have some time for questions and answers with students?
Yes, well, I'm quite happy to do it that way, though I would have preferred it if you had done a Q&A, and that's very easy on me. But
I made it harder for you.
However, we have two papers which I understand have been distributed, and they will give a background, and I don't want to repeat everything that is said in those two papers because nothing on this subject has significantly changed since those papers were written. One of them was written at the time of my retirement from the High Court. That's the paper on the High Court and law reform, which was published in the Alternative Law Journal, and the other is the decline and fall of law reform institutions, which is published in the Australian Law Journal. Let me start by acknowledging the First Nations people. We've got to learn to do this sincerely and not just as a routine in Australia. In that sense, we can learn a few lessons from law reform and institutional reform in New Zealand. It oughtn't to be a routine for lawyers because, first of all, lawyers played a very significant part in changing the law in relation to the rights of First Nations people. And I'm referring, of course, to the Mabo decisions. I called on Sir Gerard Brennan, who wrote the leading opinion in the Mabo case. He's in hospital and hasn't been well, but I told him that I was speaking to a number of law schools about his mighty contribution to the law in respect of the First Nations people, and that pleased him greatly. The involvement with law reform was a somewhat accidental thing, at least as far as I was concerned. When I was a barrister, I lived in the age of orality, which is to say most of my day was taken up on my feet, talking in courts and tribunals about the problem in hand, the case, and how it should, in my submission, be resolved. So I was just so busy that I didn't have much time for institutional law reform. In any case, such institutional reform as existed at the time I was originally appointed to judicial office in 1975 was really a group of very senior lawyers meeting at 5 p.m. on a Friday over a glass or two of whiskey and talking about how good the law was and it didn't need too much reform. It was not a feature of that time that law reform committees could do any task that was very large, very complicated, required social data, required broad consultation with the community, had any real controversy about it, and it was therefore substantially confined to a very narrow band of highly technical issues, and even these often took a long time to get enacted. But that was the way of law reform when I was at law school and when I was at the bar, and it remained so for some time thereafter, and it shows dangerous tendencies to be returning to that old model of law reform. Just to prove how sometimes imaginative politicians can make a real difference, Lionel Murphy was appointed by Gough Whitlam when he was elected to lead the Labor Party into government in 1972. Lionel was appointed as the Federal Attorney General, and he therefore had a very significant role to play in the federal statute book and in the development of the law. And he made it his business to seek and secure the enactment of a lot of law reform measures. There was a very good movie made about Lionel Murphy at about the time of his death, and it was called Mr. Neil is Entitled to be an Agitator. And that was a quote from Lionel Murphy's reasons for judgment in the High Court of Australia, to which he was later appointed in 1975, in the case of Neil against the Queen, in which Mr. Neil, First Nations citizen of Australia, had been prosecuted and convicted at trial and in the Intermediate Court for police offence of agitating in a public place and making a thorough nuisance of himself. Justice Murphy, in the course of his reasons, which looked, as typically he did, overseas and often to America, to the role of agitators in history. And in his reasons, he made a long list of the great agitators of history. And he concluded that Mr. Neil, coming from the background as an Indigenous Australian, had good reason to agitate, and that he was not entitled to be put down because he was agitating, and that this was an important part of a free society. This morning, in my chambers, which are opposite the New South Wales State Parliament in Macquarie Street, Sydney, there was a very big demonstration of teachers in New South Wales public schools, and they were agitating against the unfairness of the current salaries paid to teachers and the support given by governments to public education. And it wasn't only because I honour my own public education and my own teachers in public schools, but also because of the principle of the thing. I thought it was a very good thing that these teachers and citizens, they were nurses last week, but today it was teachers, agitating. That's a very important aspect of our democratic political arrangement. And unfortunately, largely as a result of the ill thought out action of a few agitators, which held up all the railway services in Sydney CBD a few weeks or months ago, legislation has been introduced into the New South Wales Parliament, and I think already passed, with the support of both sides of politics, to make even more prohibitory and even more limited the circumstances in which citizens could meet and assemble and and agitate. I think that's a very bad development, and I hope it will be reversed. But it was supported both by the Liberal National Party government in New South Wales and by the Australian Labor Party. So sometimes times change, and we need law reformers to point out the good of any reform, but also the dangers and the principles that are sometimes involved. Anyway, in the 1960s in England, a very great lawyer and judge, Sir Leslie Scarman, later Lord Scarman, proposed to the Wilson government that there should be an institutional rearrangement that would establish the law commissions, the Law Commission of England and Wales and the Law Commission of Scotland. They were both separate because, as you would know, the Scottish law is in many respects more similar to European legal tradition and is different from the English common law and, in some respects, the English statute law. So Scarman created and led the original Law Commission of England and Wales, and Lord Hunter was his counterpart in Scotland, and they did a lot of wonderful things in setting up an institution which had a good mix of judges, practicing lawyers, academics, and sometimes people whose expertise was not law. And they piloted through a large number of important inquiries, which were publicly advertised and the subject of consultation with politicians, with academics, and with the community and the interested institutions. And that led to a series of reports, but above all, to a good example that was placed before countries of the Commonwealth of Nations, including Australia. That example was effectively saying the law, the state of the law, is too important and too much a part of how we live and how we are governed to delay an institutional approach to law reform, that we needed something more regular and institutional than a group of lawyers on a 5 p.m. on a Friday afternoon meeting over a glass of whiskey. And the creation of the English Law Commission and the Scottish Commission was later followed in Ireland. There had been a similar commission created a few years earlier in India. And gradually, all through the Commonwealth of Nations, it was recognized that the parliamentary system, though it had certain advantages, many advantages, but it needed gingering up. And that was unlikely to happen from within Parliament itself, at least happen often enough from within Parliament itself, and it therefore needed an institutional change. And the Scarman model became the institutional change that was basically copied in Commonwealth countries, including by the Law Reform Commission Act of the Federal Parliament, which was enacted in 1972. That act was not brought into effect until 1975. And when it was brought into effect, Lionel Murphy, who was then still the Federal Attorney General, went looking around for somebody to head the Law Reform Commission, the ALRC, and his eyes settled on me. And he invited me over to see him in his chambers in Sydney. I didn't really know Lionel Murphy very well. I did know Neville Wran, who had been a silk in New South Wales, doing a lot of cases in the industrial tribunals. And he was a very close friend to Lionel Murphy. And I suspect that it was Neville Wran's intervention that led to the approach to me. Geoffrey Robertson, QC, who was later to become extremely famous as an Australian lawyer working in England on behalf often of disadvantaged people. He came with me to see Lionel Murphy. And he said to me as we were hurrying to the Federal Attorney General's suite in a nearby building, he said, if you're offered the Law Reform Commission, you've got to grab it, because this is what Lord Scarman did, and it will be very good for you and good for Australia. But I had just been appointed a deputy president of the Australian Conciliation Arbitration Commission. I didn't really want to do something different. I rather liked being a judge of the Arbitration Commission. However, Lionel Murphy asked me to accept appointment. I said to him that he should look for somebody older, wiser, and more acceptable to the profession. And he said, no, that's rubbish. I don't intend to do that. I want somebody who is young, energetic, and who will breathe a lot of life into this and do things differently and stir things up. And I think I did all of those things. I was almost as energetic then as I am now. And so I brought a lot of energy to the task, a lot of consultation to the task. And in fact, I was thinking only recently, if you examine my life, if I examine my life, a common theme in a lot of the things I have done is the need for transparency, a need to be responsive to ordinary citizens, and a need to consult and to be open to new information, including new social and empirical data. And so the ALRC was set up. I became the chair, and we gathered together lawyers of the greatest distinction, and including a very young Mr. F.G. Brennan, QC of the Brisbane Bar, who was later to be a Justice of the High Court and Chief Justice of the High Court. And so we got to work on our tasks. We advertised our inquiries. We held public hearings. We invited the profession and institutions to assist us. And that went on as long as I was in the chair of the ALRC, which was until 1984. When I, many years later, became chair of the Commission of Inquiry of the United Nations on Human Rights in North Korea, I did much the same thing. We had an institutional approach. We invited the media. We engaged with the media. We invited community groups and experts and professionals that were relevant. And that was done in that case so many years after the ALRC was established. I think it's fair to say the ALRC was extremely successful in the first decade or more of its establishment. And I attribute a lot of its success to the engagement with the media. Our parliamentary system works pretty well if you can get your message out to the general community. But there's a big risk that you will be ignored if you're doing good works in a back room over a glass of whiskey and not doing things in a very open and transparent way. The result of all this was that in the early years of the ALRC, we had many of our reports implemented, because if they weren't implemented, I would drop hints on the media about the need for attention to this or that, and I never let up. I just kept referring to the need to follow up the proposals. And I think that was a good thing. A good thing happened after the dismissal of Mr. Whitlam, that Mr. Fraser had appointed as his Attorney General the Honourable Bob Ellicott. He was an extremely accomplished lawyer, barrister, QC. He had been the Federal Solicitor General, and he was appointed as Federal Attorney General by Mr. Fraser, and he, far from abolishing the ALRC, was extremely enthusiastic for institutional law reform. He knew about Scarman, he knew about his work, and he wanted to do likewise in Australia. And in fact, the work of the ALRC went beyond the type of work that Scarman and the English Law Commission did. They tended to do rather technical issues of law, whereas we tended to do some technical issues, but also issues where there were very significant policy questions, such as the law on how to handle complaints against the police, or how to make laws on human tissue transplantation, or how to reform the laws of defamation, or how to reform sentencing. These were all very big issues, and they could only have a chance of success if our consultation went beyond just the mere experts, but included members of the general community, members of the legal profession and others, members of the institutions that would be affected by any reform. And all of that was the way we operated. And indeed, the ALRC operated in that way for most of the last century. And it invited very respected and top lawyers to be considered for appointment by the Governor General on the advice of the Federal Attorney General in order to do the work of law reform. And that itself contributed to the implementation of the reports. There were many discussions about whether we could introduce some automatic system, that there would be an automatic procedure for the implementation of law reform. We had noticed that many law reform bodies failed because their report was simply put in the bottom drawer. Nobody paid attention to them. Something had to be done to leap over the inactivity once a report was produced. And although there was a lot of debate about this and Senate committees considered it, nothing much was done to introduce a systematic reform process that would shuffle the reports along, that would make sure that they were considered and make sure that Parliament at least considered whether to implement the report or not. However, by the end of the century and early in the new century, even that measure of attention to the Commission began to wane. It waned in the appointment of commissioners who were very well known in the legal profession. It waned in the extent to which public hearings were conducted. It waned in the capacity of the commissioners to involve the media and to make issues of law reform significant for ordinary people, and to give them a voice in what should be done. And as is pointed out in my ALJ article, the graphical representation of the number of reports and the expenditure of money on the commission and the implementation of reports can be shown to have seriously declined in the period of the 21st century. And this is both a tragedy for the failure to follow the model, the Scarman model, which we had pioneered and substantially improved in Australia. And that despite the fact that we had a very good rate. I think at the end it was about 70% of our reports were implemented, but that was only because we kept banging the table and making the matter a matter of public record and public pressure built up behind it. But in the 21st century, there was a fall off, even to the point that the Commission almost self-immolated. It almost disappeared because it didn't have any references from the Federal Attorney General, and that led to the drift away from appointing part-time commissioners from the legal leaders of the legal profession, and that led to a failure to deal with large controversial topics, because the methodology was not being employed of consulting the general public, and that led to a serious reduction in both the output of the ALRC and of other state and territory law reform bodies, but also a reduction in implementation and public attention to and involvement in and interest in institutional law reform. And so that is where basically things still remain. Attorneys General, and this is not just coalition attorneys general, Labor Party attorneys general, had political leaders who were not very interested in law reform, and indeed they saw them as a threat to, I think, a threat to their control over the controversies that were occurring in society. And the net result of all this was that the law reform bodies began not to have work, not to have commissioners to do any work, not to have controversial, interesting and socially relevant and urgent tasks, to have tasks which were literally extracted from the Federal Attorney General, Labor or non-Labor, like a tooth was being extracted simply to keep the show bubbling along at a very minimum pace. This also happened to the Administrative Review Council, which was like a special law reform commission for administrative law. And the way that was dealt with was that although it remained on the statute book, probably because the government that wanted to abolish it didn't have the numbers in the Senate, but no additional non-statutory appointees were added to the Administrative Review Council, which had been such a vibrant body at the time that I was a member of it, ex officio from the Law Reform Commission, and it simply didn't have any work to do. No projects were assigned to it. And that seems to be a new technique where parliamentary abolition, which would be necessary, doesn't have to be tried. You just don't appoint anybody to them, and no money is given to them, and therefore nothing much gets done. And ultimately, because I felt a loyalty to all the people who'd worked on law reform in the ALRC, I wrote that article, and I'll never stop referring to the need to get back to the way things were following the Scarman model. Indeed, the Scarman model can be improved, as they've shown recently in England, by adopting a system of referring matters to a parliamentary committee automatically, so that attention will be paid to a report and it won't get put in the little bottom drawer. But we haven't done that. We've gone the other way in Australia. We simply don't appoint people, and we don't give proper money that would be appropriate to a body that has a big, viable and vibrant a group of references upon which the commissioners can work and the public can be consulted and the system can be improved. You should have an Auditor General for honesty in the governmental system, as we do, but you should also have a kind of auditor of the substance of the law. If you were an order and systems expert and looked at the form of government we have in Australia, you'd be horrified about the failure to produce an institutional response to the orderly, regular improvement of the law. Now, the other paper that I prepared was on judicial reforms, and I listed there a series, there'd be about 15 of them, of things that could be done by the High Court of Australia of its own motion, or with the support of the Federal Attorney General to get legislation where that was necessary. Many things could be done just by changes within the court. And the proposals, the suggestions I made are in that paper. And I think reading them again today, I would adhere to them all, and I think they deserve attention. In fact, whatever the outcome of the present federal election, I think I'll send a copy of that report and of the ALJ report, prompted by Liam's action. And I hope and expect the outcry from Liam's students to get follow-up. In fact, in one way, I think reform has gone backwards as far as the High Court is concerned in terms of adapting its mechanisms. One of them is in terms of the number of cases that are now dealt with, quote, on the papers. When the High Court had a flood of cases involving refugee applicants, some relief was given at that time in refugee cases to allow special leave applications to be dealt with on the papers, which meant written submissions that never got into court, that required a special order of 2 or more justices, and generally that was not forthcoming. Cases were simply dismissed, very occasionally allowed, and it was dealt with without oral input. I myself don't think that is a good development. The Queen once said of her office, "You've got to be seen to be believed." And I think the same can be said of the High Court of Australia. You've got to be seen going around the traps, sitting in all of the state capitals, sitting in Darwin, and dispensing justice. This is what the English kings did in the reign of King Henry II. back in medieval times, because he knew the importance of seeing is believing. And the same is true of the High Court of Australia. Dealing with things on the papers may lead to greater unanimity, but it isn't necessarily the best system for dealing with applications, which must generally be of some controversy and some significance if they have any chance of getting up. And the fact that this is now all done behind closed doors is, if I can say so with great respect, as we have to say, something antithetical to the general principle of open administration of justice and of transparency and of allowing the public to judge the judges, which is a very important feature that should permeate our system. So I adhere to my view that the reform of the retirement age of federal judges, including justices of the High Court at 70, was a good development. I voted for it when the constitutional referendum was produced. Some people say, oh, it's a terrible thing. Look at all those very able judges who are put out to pasture long before their time. Look at Justice Kirby, for example. He's still doing all these United Nations inquiries. He should be back at work in the High Court of Australia, sitting in public and dealing with the matters. Well, I can understand that view about my merits, but it doesn't make any difference. I don't agree with reversing the constitutional change. I think it was a good change. And one of the best features of the change was that the views that people have are largely settled in their school days. And I don't know if any of you have seen that program 7 Up that traced young English people through their lives from different groups in the community, poor and rich, university educated and barely educated at all, and how your basic values are often settled very early. And that, if that is so, my basic values were probably settled in my mind round about the 1950s, when I did the school hire certificate, then called the leaving certificate. And therefore, by the time I was destined to retire, which was 2009, that was a long way back. And it's important to have different values, different life experiences, different attitudes to religion, for example, different attitudes to technology, for example, different capacity to use technology. And I think that's why this was a good move, but it should also be coming in common with attempts to make for a wider variety of appointees. We still have never had a Justice of the High Court of Australia from Tasmania or South Australia. And I list in my article just some of the very able judges, including more recently now, Chief Justice Doyle and other fine judges in South Australia who would have made excellent justices of the High Court, but they were never given the chance. So you might say that from a reluctant entrant into the world of institutional law reform, when Lionel Murphy invited me to his chambers with Jeffrey Robertson in tow to have a glass of champagne, they were the days when I was appointed, and my whole view about law reform was altered by studying the English model, by looking at our system of governance and its need for improvement, and then by serving for 12 years as chair of the Australian Law Reform Commission. Look at the situation today with a typical case. It's a case that concerns the right of a second appeal of a suspect case where it's alleged that a person has been wrongfully convicted. Now, there have been such cases, you know. I'd hate to let those who don't think they exist in Australia, but there have been such cases. One of them did get special leave to appeal for a second time, and eventually the case was decided in favour of the accused, the prisoner, Mr. Mallard and the Queen. It's a very important case. And the issue also arose in the criminal conviction of Cardinal George Pell. But not everybody can get into the High Court of Australia. Again, we need an institutional reform. And one such reform would be to permit a second appeal to a Court of Criminal Appeal by leave of the Court of Criminal Appeal on the proof of substantial and convincing evidence, new evidence. And that shouldn't take a long time for people to consider that against the background of very significant cases in Australia where there has been a miscarriage of justice. But though the legislation introduced in South Australia was copied then in Tasmania and subsequently in Victoria, it's still being considered in Western Australia, and it hasn't even been considered, as far as I know, in South Australia and in Queensland and in the Northern Territory. So why should that take such a long time? It's a very small amendment. It's the sort of amendment that maybe in the old days would be dealt with a glass of whiskey on a Friday afternoon. But for some reason, possibly they think we are the best system in the world. Well, we're not. It isn't implemented and hasn't even been considered or discussed. And that's really a very bad aspect of our current management of law reform. And there's a further reform that has been introduced in England, in New Zealand, in Scotland, in Ireland, and in Canada, which is to establish a suspect cases review commission to allow an expert commission to supplement the work of the Courts of Criminal Appeal. Okay, it'll cost money, but if it prevents serious miscarriages of justice and if there's strong and compelling reasons for reconsideration, instead of that matter being dealt with late on a Friday or Wednesday afternoon in a Court of Criminal Appeal by 3 overworked judges, their work would be supplemented by a commission with access to better technical and forensic evidence. And if it was good enough for England, Scotland, Ireland, Canada, New Zealand, why should it take years for that to be considered in Australia and not to be implemented even on an experimental basis in any of the states of Australia or any of the territories? This is really the problem we face. And it's a problem that requires a systemic difference and systemic change, and especially a change that is the subject of scrutiny in the media and in the public. And I think that's a lesson that we should draw from history. So my views have not reverted. As I get older, I'm not becoming more conservative. My views have strengthened, that we have a problem here. We have an institutional problem in lawmaking and auditing the law as a phenomenon in our governance, and that ought to be the subject of the introduction of new mechanisms, improving institutional law reform and implementing on a streamlined basis the proposals that come after their inquiries. And I hope that that may be some help and contribution to the class at Monash, and I congratulate you all. Think boldly. Don't think in a boring manner. Don't think in a purely formalistic manner about the law. Our profession, if it has a nobility, is that it is a profession dedicated ultimately to justice. It's justice according to law, but it's justice, and you shouldn't forget the justice aspect. And I'm at the moment reading a book on the last 50 miles in the First World War. And it's a book that tells the story, amongst others, of General Sir John Monash, and how he thought boldly, he thought creatively. He introduced reforms, often with the opposition of the General Staff and others, sometimes with opposition because he was Jewish. But he persisted and played a very big role in bringing the First World War to a close by intercoordinating the military, the Air Force, and the naval powers. And if we all could learn from Monash, who was a lawyer, an engineer, but also a lawyer, and think in a reformist way, the good governance of the Australian people would be improved.
Thank you so much, Justice Kirby. That was fantastic. And I feel like I've learned a lot from that.